Welcome to SNS Academy. I am Satyanarayana Sir. Good evening, students. We have already discussed about Indian polity by M. Laxmikanth. That's chapter 8. First part already uploaded. ये चैप्टर है फंडामेंटल राइट्स, मौलिक अधिकार, जो आज शुरुआत होगा एबोलिशन ऑफ अनटचेबिलिटी, जिसको छुआछूत बोला जाता है, अस्पृश्यता, इसको हटाना चाहिए और ये दंडनीय है, पनिशेबल है. आर्टिकल 17 abolishes untouchability and forbids its practice in any form. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. जो कि छुआछूत पहले से था, दलित ये सब कैटेगरी का आदमी पढ़ने से वंचित हो रहे थे, तो उन लोगों को अधिकार से वंचित किया जाता था. तो ये एक दंडनीय है, इसको हटाया गया है. अस्पृश्यता से उपजी किसी भी मतलब कानून हो या इसको अपराध, कानून को लागू करना अपराध होगा. After that, in 1976, the Untouchability Offences Act 1955 has been comprehensively amended and renamed as the Protection of Civil Rights Act 1955 to enlarge the scope and make penal provisions more stringent. The Act of Defines, तो यहाँ पर क्या किया गया, 1976 में अनटचेबिलिटी का नाम बदला गया, जो कि रीनेम्ड क्या किया गया, रीनेम्ड एज द प्रोटेक्शन ऑफ सिविल राइट्स एक्ट 1955 टू एनलार्ज द स्कोप एंड मेक पेनल प्रोविजंस मोर स्ट्रिगनेंट. द एक्ट डिफाइंस सिविल राइट्स एज एनी राइट acquiring to a person by reason of the abolition of untouchability by Article 17 of the Constitution. The term untouchability has not been defined either in the Constitution or in Act. यहाँ पूरा डिफाइन नहीं किया गया है क्या चीज़ अनटचेबिलिटी है बोलकर. However, the Mysore High Court held that the subject matter of Article 17 is not untouchability in its literal or grammatical sense, but the practice as it had developed historically in the country. It refers to the social disability imposed on certain classes of persons by reason of their birth in certain caste. Hence, it does not cover social boycott, इसको cover नहीं करता है social boycott of a few individuals or their exclusion from religious services, etc. In the People's Union for Democratic Rights case 1982, the Supreme Court held that the right under Article 17 is available against private individuals and it is the constitutional obligation of the states to take necessary action to ensure that this right is not violated. After that, abolition of titles. टाइटल का एबोलिशन, जैसे कोई राय बहादुर और जो टाइटल था उसको नहीं ले पाएगा, वो दंडनीय है. आर्टिकल 18 abolishes titles and makes 4 provisions in that regard. It prohibits the state from conferring any titles except a military or academic distinctions on anybody, whether a citizen or a foreigner. It prohibits a citizen of India from accepting any title from any foreign state. A foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the president. No citizen or foreigner holding any office of profit or trust under the state is to accept any present emolument or office from or under any foreign state without the consent of the president. From the above, it is clear that the hereditary titles of nobility like Maharaja, Raj Bahadur, Rai Bahadur, Rai Sahib, Dewan Bahadur, etc., which were conferred by colonial states are banned. ये सबको बैन किया गया by Article 18 as these are against the principle of equal status of all. In the Balaji Raghavan case, the Supreme Court upheld the constitutional validity of the national awards, जो कि भारत रत्न, Padma Vibhushan, Padma Bhushan, and Padma Shri. It ruled that these awards don't amount to titles within the meaning of Article 18 that prohibits only hereditary titles or nobility. Therefore, there are not violative of Article 18 as the theory of equality does not mandate that merit should not be recognized. However, it also ruled that they should not be used as suffix or prefix to the names of awardees, otherwise they should forfeit the awards. एवर्ड्स का प्रीफिक्स और सफिक्स में कुछ यूज नहीं होगा, अगर यूज होगा तो उसको फॉरफिट मतलब उसको वैल्यू नहीं रहेगा. These national awards were instituted in 1954. The Janata Party government headed by Morarji Desai discontinued them in 1977. But they were again revived. वो again revived हुआ कब 1980 में by the Indira Gandhi government. The Padma Awards are announced every year. Padma Awards सभी साल को अनाउंस किया जाता है on the occasion of Republic Day. पद्मश्री, पद्म भूषण, पद्म विभूषण ये सब रिपब्लिक डे में अनाउंस होता है, एक्सेप्ट फॉर ब्रीफ इंटरप्शन ड्यूरिंग द ईयर 1978 and 79 and 1993 and to 1997. The total number of Padma awards to be given in a year, excluding posthumous awards and award given NRI means non-residential Indian foreigners, OCIs should not be more than 120. Similarly, the number of Bharat Ratna awards is restricted to a maximum of 3 in a particular year. भारत रत्न 3 को दिया जाता है. राइट टू फ्रीडम, उसका बाद आता है राइट टू फ्रीडम. जो फ्रीडम कहाँ कहाँ पर कॉन्स्टिट्यूशन में दिया गया है, जैसे फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, राइट टू असेंबल पीसफुली and without arms, right to form association or unions or cooperative societies, right to move freely, move कर सकते हो throughout the territory of India, right to reside and settle in any part of the territory of India, right to practice any profession or to carry on any occupation, trade or business. Originally, Article 19 contained 7 rights. 7 rights वो contain करता है, but the right to acquire, hold and dispose of property was deleted by the 44th Amendment Act of 1978. These 6 rights are protected against only state action. These 6 rights are protected against only state action and not private individuals. Moreover, these rights are available only to the citizens and to shareholders of a company, but not to foreigners or legal persons like companies or corporations, etc. The state can impose reasonably restrictions स्टेट इम्पोज करता है रीजनेबल रेस्ट्रिक्शंस ऑन द एन्जॉयमेंट ऑफ दिस 6 राइट्स only on grounds mentioned in the Article 19 itself and not on any other grounds. The 6 rights contained in Article 19 and the grounds of imposing reasonable restrictions on them are mentioned. उसका बाद freedom of speech and expression. It implies that every citizen has the right to express his or her views. ये डिसाइड करता है जो हर आदमी अपना ओपिनियन, विश्वास और उसका जो एक्सपीरियंस वो फ्रीली बोल सकता है बाय वर्ड ऑफ माउथ, राइटिंग, लिख कर, बोलकर, ओरली बोलकर, लिखकर या प्रिंटिंग, पिक्चरिंग और एनी अदर मैनर. The Supreme Court held the freedom of speech and expression includes the following. दिया गया है जैसे राइट टू प्रोपोगेट वंस व्यूज, एक आदमी का अपना व्यू, फ्रीडम ऑफ द प्रेस, फ्रीडम ऑफ कमर्शियल एडवर्टाइजमेंट, राइट अगेंस्ट टैपिंग ऑफ टेलीफोनिक कन्वर्सेशन, राइट टू टेलीकास्ट दैट is government has no monopoly on electronic media, right against band called by a political party or organization, right to know about government activities, freedom of silence, right against imposition of pre-censorship on a newspaper, right to demonstration or picketing but not right to strike, हड़ताल करने, right to fly the national flag, right of voters to know the antecedents of the candidates contesting elections, right to choose the medium of instruction at the stage of primary school. वो चूज कर सकता है प्राइमरी स्कूल में कौन सा वो लैंग्वेज, कौन सा इंस्ट्रक्शन दिया जाएगा. राइट टू एक्सप्रेस जेंडर आइडेंटिटी, दीज आर द थिंग्स. राइट टू रिप्लाई, राइट टू आंसर द क्रिटिसिज्म का आंसर देना है. राइट टू पोस्ट इंफॉर्मेशन वीडियोस ऑन इंटरनेट सोशल मीडिया, राइट टू फिल्म मेकर्स टू एग्जिबिट देयर फिल्म्स, राइट टू एक्सेस टू द इंटरनेट, राइट टू access to information. The state can impose reasonable restrictions on the exercise of the freedom of speech and expression on the grounds of sovereignty and integrity of India. Sovereignty जो सार्वभौमत्ता, इंटीग्रिटी, ये सब रहना चाहिए. सिक्योरिटी ऑफ द स्टेट, फ्रेंडली रिलेशन विथ फॉरेन स्टेट्स, सभी के साथ अच्छा रिलेशन रहना चाहिए. पब्लिक ऑर्डर, डिसेंसी और मोरालिटी, कंटेम्प्ट ऑफ कोर्ट, कोर्ट का अवमानना नहीं करना चाहिए. डिफेमेशन एंड इंसाइटमेंट टू एनी ऑफेंस. यहाँ पर जो राइट्स का उसका लिमिटेशन लिखा गया है, जैसे एवरी सिटीजन हैज़ द राइट टू असेंबल पीसफुली एंड विदाउट आर्म्स. हर नागरिक का अधिकार रहता है जो वो असेंबली करे जो कि पीसफुली, और वहाँ पर कुछ वेपन्स लेने का अलाउ नहीं है. इट इंक्लूड्स द राइट टू होल्ड पब्लिक मीटिंग्स, डेमोन्स्ट्रेशंस एंड टेकआउट प्रोसेशंस. दिस फ्रीडम कैन बी एक्सरसाइज्ड ओनली ऑन पब्लिक लैंड and the assembly must be peaceful and unarmed. This provision does not protect violent, disorderly, riotous assemblies, or one that cause breach of public peace, or one that involves arms, जो कि आर्म में इन्वॉल्व हो सकता है. This right doesn't include the right to strike. The state can impose, कर सकता है, reasonable restrictions on the exercise of right of assembly on two grounds, namely sovereignty and integrity of India, and public order including the maintenance of traffic in the area concerned. अंडर सेक्शन 144 ऑफ क्रिमिनल प्रोसीजर कोड, जो कि क्रिमिनल प्रोसीजर कोड है, ए मजिस्ट्रेट कैन रिस्ट्रेन एन असेंबली मीटिंग और प्रोसेशन इफ देयर इज ए रिस्क ऑफ ऑब्स्ट्रक्शन, annoyance or danger to human life, health or safety, or a disturbance of the public tranquility or a riot or any affair. अंडर सेक्शन 14 ऑफ द इंडियन पेनल कोड, जो कि 14 का है इंडियन पेनल कोड, एच असेंबली ऑफ 5 or more persons become unlawful if the object is to resist the acquisition of any law or legal process, to forcibly occupy the property of some person, to commit any mischief or criminal trespass, to force some person to do an illegal act, and to threaten the government or if its officials on exercising lawful powers. अंडर सेक्शन 141 ये इंडियन पेनल कोड में क्या एन असेंबली ऑफ 5 or more persons बिकम अनलॉफुल है इफ द ऑब्जेक्ट टू रेजिस्ट द एक्विजिशन ऑफ एनी लॉ और लीगल प्रोसेस, टू फोर्सिबली ऑक्यूपाई द प्रॉपर्टी ऑफ सम पर्सन, अगर किसी का प्रॉपर्टी को हड़प किया जाता है उस समय वो पनिशेबल है, टू कमिट एनी मिसचीफ और क्रिमिनल ट्रेसपास, अगर कुछ क्रिमिनल हुआ उस समय अधिकार को सस्पेंड किया जाता है, टू थ्रेटन द गवर्नमेंट को थ्रेटनिंग देने में सस्पेंड किया जाता है. फ्रीडम ऑफ एसोसिएशन, all citizens have the right to form association or unions or cooperative societies. हम एसोसिएशन कर सकते हैं कुछ डेवलप करने के लिए, कुछ डिस्कस करने के लिए, कुछ ऑब्जेक्टिव्स लेकर कुछ काम करने के लिए. इट इंक्लूड्स द राइट टू फॉर्म पॉलिटिकल पार्टीज हुआ, कंपनीज, partnership, farms, societies, clubs, organization, trade unions, or any body persons. If not only includes the right to start an association or union, but also continue with the association or unions as such. Further, it covers the negative right of not to form or join an association or union. Reasonable restrictions can be imposed. वहाँ पर reasonable restriction impose किया जा सकता है on the exercise of the right by the state on the grounds of sovereignty and integrity of India. अखंडता और सार्वभौमता सुप्रीम पावर को बेस का साथ मेंटेन किया जाता है. पब्लिक ऑर्डर एंड मोरालिटी, सब्जेक्ट ऑफ टू दीज रेस्ट्रिक्शंस द सिटीजन्स हैव कंप्लीट liberty to form association or unions for pursuing lawful objectives and purposes. However, the right to obtain recognition of the association is not a fundamental right. The Supreme Court held that the trade unions have no guaranteed right to effective bargaining or right to strike or right to declare a lockout. The right to strike कैन बी कंट्रोल, वो कंट्रोल होता है बाय एन अप्रोप्रिएट इंडस्ट्रियल लॉ. फ्रीडम ऑफ मूवमेंट, जो फ्रीडम ऑफ मूवमेंट रहता है, दिस फ्रीडम एंटाइटल्स एवरी सिटीजन टू मूव फ्रीली थ्रू आउट द टेरिटरी ऑफ द कंट्री. ही सी कैन मूव freely from one state to another or from one place to another within a state. This right underlines the idea that India is one unit so far as the citizens are concerned. Thus, the purpose is to promote national feelings and not partialism. द ग्राउंड्स ऑफ इम्पोजिंग, जो इम्पोजिंग करना, द ग्राउंड्स ऑफ इम्पोजिंग reasonable restrictions on this freedom are two, namely the interest of general public and the protection of interest of any scheduled tribe. The entry of outsiders in tribal areas is restricted to protect the distinctive culture, language, customs, and manners of scheduled tribes and to safeguard their traditional, safeguard करना चाहिए, traditional vocation and properties against exploitation. The Supreme Court held that the freedom of movement of prostitutes can be restricted. वो restricted है on the ground of public health and in the interest of public morals. The Bombay High Court validated the restrictions on the movement of persons affected by AIDS. द फ्रीडम मूवमेंट हैज़ टू डायमेंशन, दो डायमेंशन रहता है जो कि इंटरनल और एक तो है एक्सटर्नल. इंटरनल राइट टू मूव इनसाइड द कंट्री और एक्सटर्नल जो कि है राइट टू मूव आउट ऑफ द कंट्री एंड राइट टू कम बैक टू द कंट्री और फिर लौट आना. आर्टिकल 19 प्रोटेक्ट्स ओनली द फर्स्ट डायमेंशन. द सेकेंड डायमेंशन इज dealt by Article 21, right to life and personal liberty. Freedom of residence. Every citizen has the right to reside and settle in any part of the territory of the country. सभी सिटीजन को दिया गया है इंडिया का जो प्लेस उन लोगों को अच्छा लगे वहीं पर वो रह सकता है. दिस राइट हैज़ टू पार्ट्स, उसका दो पार्ट रहता है. द राइट टू रिसाइड इन एनी पार्ट ऑफ द कंट्री which means to stay at any place temporarily, and the right to settle in any part of the country, जहीं पर भी सेटल होना है, which means to set up a home or domicile at any place permanently. This right is intended to remove internal barriers within the country or between any of its parts. This promotes nationalism, वो nationalism को promote करता है. nationalism मतलब एक जगह का कल्चर, एक जगह का लैंग्वेज, वो सभी का यूनिफॉर्मिटी होना चाहिए. एंड अवॉइड नैरो माइंडेडनेस. द स्टेट कैन इम्पोज रीजनेबल रेस्ट्रिक्शन, वहाँ पर देखा जाएगा, वहाँ पर भी रीजनेबल रेस्ट्रिक्शन पुट किया जाता है ऑन द एक्सरसाइज ऑफ दिस राइट ऑन टू ग्राउंड्स, नेमली द इंटरेस्ट ऑफ जनरल पब्लिक एंड द प्रोटेक्शन ऑफ इंटरेस्ट ऑफ एनी शेड्यूल्ड ट्राइब्स. एक जो वहाँ पर जो आदमी रहता है उन लोगों का इंटरेस्ट और दूसरा है इंटरेस्ट ऑफ एनी शेड्यूल्ड ट्राइब्स. द राइट ऑफ आउटसाइडर्स टू रिसाइड एंड सेटल इन ट्राइबल एरियाज इज रेस्ट्रिक्टेड टू प्रोटेक्ट द डिस्टिंक्टिव कल्चर, लैंग्वेज, कस्टम एंड मैनर्स ऑफ शेड्यूल्ड ट्राइब्स एंड टू सेफगार्ड देयर ट्रेडिशनल वोकेशन एंड प्रॉपर्टीज अगेंस्ट एक्सप्लॉइटेशन. जो कोई बाहर आदमी आकर वहीं पर जो आदमी रहता है उस उन लोगों का कल्चर, ट्रेडिशन, ये सब में डिस्टर्ब होना नहीं चाहिए, ये सब में इंटरफेयर होकर नहीं करना चाहिए. इन मैनी पार्ट्स ऑफ द कंट्री द ट्राइबल्स हैव बीन परमिटेड टू रेगुलेट देयर प्रॉपर्टी राइट्स इन अकॉर्डेंस विद देयर कस्टमरी रूल्स एंड लॉज. कोई कोई जगह में ट्राइबल लैंड का कुछ नियम रहता है जो कि दूसरे आदमी, दूसरे कैटेगरी जो वहाँ का इनहेबिटेंट्स नहीं है, वो वहाँ का कॉमुनल में नहीं आते हैं, उन लोगों को प्रॉपर्टी ट्रांसफ़र के लिए कुछ रेस्ट्रिक्शन रहता है. द सुप्रीम कोर्ट हेल्ड दैट सर्टेन एरियाज कैन बी बैंड फॉर सर्टेन काइंड्स ऑफ पर्सन्स लाइक प्रोस्टिट्यूट्स एंड हैबिचुअल ऑफेंडर्स. From the above, it is clear that the right to residence and the right to movement are overlapping to some extent. रहना और मूवमेंट करना उसमें कुछ रेस्ट्रिक्शन रहता है. बोथ आर कॉम्प्लीमेंटरी टू ईच अदर. फ्रीडम ऑफ प्रोफेशन एक्सेट्रा. फ्रीडम ऑफ प्रोफेशन, कोई भी क्या धंधा करेगा, क्या उसको कैरियर चूज करेगा, वो अपना ऊपर डिपेंड करता है, उसमें कुछ कोई बाई फोर्स नहीं कर पाएगा. ऑल सिटीजन्स आर गिवन द राइट टू प्रैक्टिस एनी प्रोफेशन और टू कैरी ऑन एनी ऑक्यूपेशन, ट्रेड और बिजनेस. दिस राइट इज वेरी वाइड as it covers all the means of earning one's livelihood. The state can impose reasonable restrictions on the exercise of this right in the interest of the general public. Further, the state is empowered to first prescribe professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade, or business, and carry on by itself any trade, business, industry, or service, whether to the exclusion of citizens or otherwise. Thus, no objection नहीं है, can be made when the state carries on a trade, business, industry, or service either as monopoly, complete or partial, to the exclusion of citizens, all or some only, or in competition with any citizen. The state is not required to justify its monopoly. This right doesn't include नहीं है the right to carry on a profession or business or trade or occupation that is immoral, trafficking in women or children or dangerous, harmful drugs or explosives, etc. The state can absolutely prohibit these or regulate them through licensing. In Anuradha Basin case, the Supreme Court held that the freedom to practice any profession, Supreme Court क्या करता है ना, freedom to practice any profession or carry on any trade, business or occupation over the medium of internet enjoys constitutional protection. इंटरनेट भी फ्रीडम में आता है, राइट टू फ्रीडम. Under Article 19(1), the restriction on this right should be in consonance with the mandate under Article 19(6), inclusive of the test of proportionality. Further, an order suspending internet services indefinitely is impermissible under the temporary suspension of telecom services. कहीं पर भी अगर ज़्यादा देरी तक इंटरनेट बंद किया जाता है, वहीं पर पढ़ाई और कम्युनिकेशन ये सब में डिस्टरबेंस होता है, इसीलिए वो परमिसेबल नहीं है. प्रोटेक्शन इन रेस्पेक्ट ऑफ conviction for offences. Article 20 grants protection against arbitrary मतलब random and excessive punishment to an accused person. एक आदमी को बार बार और एक्सेस पनिशमेंट नहीं दिया पाएगा, और ये देने का एक पनिशेबल है टू एन accused person, whether citizen or foreigner or legal person like a company or corporation. It contains 3 provisions in that direction. No ex post facto law. No person shall be convicted of any offence except for violation of law in force at the time of the commission of the act, nor subjected to a penalty greater than the prescribed by the law in force at the time of the commission of the act. No double jeopardy. No person shall be prosecuted or and punished for the same offence more than once. No self incrimination. No person accused of any offence shall be compelled to be a witness against himself or herself. The ex post facto law is one that imposes penalty retrospectively, that is, upon acts already done, or which increases the penalties for such acts. The enactment of such law is prohibited by the first provision of Article 20. However, this limitation is imposed only on criminal laws, and not on civil laws or tax laws. In other words, a civil liability or a tax can be imposed retrospectively. Further, this provision prohibits only conviction or sentence under an ex post facto criminal law and not the trial thereof. Finally, the protection immunity under This provision cannot be claimed in case of prevention detention or demanding security from a person. The protection against double jeopardy is available only वो available है only in proceeding before a court of law or a judicial tribunal. In other words, it is not available in proceedings before departmental or administrative authorities as they are not of judicial nature. The protection against self incrimination extend किया जाता है to both oral evidence and documentary evidence. However, it doesn't extend to compulsory production of material objects, compulsion to give thumb impression, specimen signature, blood specimen, and compulsory exhibition of the body. Further, it extends only to criminal proceedings and not to civil proceedings or proceedings which are not of criminal nature. Protection of life and personal liberty. लाइफ एंड पर्सनल लिबर्टी को प्रोटेक्शन देना, उसको सुरक्षा देना, वो कौन सा आर्टिकल है? आर्टिकल 21 डिक्लेयर्स दैट नो पर्सन शैल बी डिप्राइव्ड ऑफ हिज और हर लाइफ और पर्सनल लिबर्टी एक्सेप्ट according to procedure established by law. This right is available to both citizens and non-citizens. ये both को अवेलेबल है, जो सिटीजन है, जो बाहर से आया है, वो आदमी लोग के लिए भी, सभी आदमी लोग के लिए. इन द फेमस गोपालन केस जो कि 1950 में हुआ था, द सुप्रीम कोर्ट हैज़ टेकन ए नैरो इंटरप्शन ऑफ आर्टिकल 21. It held that the protection under Article 21 is available only against arbitrary executive action and not from arbitrary legislative action. This means that the state can deprive the right to life and personal liberty of a person based on law. This is because of the expression procedure established by law in Article 21, which is different from the expression due process of law contained in the American Constitution. Hence, the validity of a law that has prescribed, वो prescribed किया गया है, a procedure cannot be questioned on the ground that the law is unreasonable, unfair or unjust. Secondly, the Supreme Court held that the personal liberty means only liberty जो कि liberty relating to the person or body of the individual. But in Menaka case, the Supreme Court overruled its judgment in the Gopalan case by taking a wider interpretation of the Article 21. Therefore, it ruled that the right to life and personal liberty जो कि personal liberty है of a person can be deprived by a law provided the procedure prescribed by that law is reasonable, fair and just and not arbitrary, fanciful or oppressive. In order that the procedure is reasonable, fair and just, the procedure should conform to the principles of natural justice. इन अदर वर्ड्स, और एक दूसरा वर्ड में बोला जाता है, इट हैज़ इंट्रोड्यूस्ड द अमेरिकन एक्सप्रेशन ड्यू प्रोसेस ऑफ लॉ इन एफेक्ट द प्रोटेक्शन अंडर आर्टिकल 21 शुड बी अवेलेबल नॉट ओनली अगेंस्ट arbitrary executive action but also against arbitrary legislative action. Further, the court held that the right to life as embodied in Article 21 is not merely confined to animal existence or survival, but it includes होता है within the ambit the right to life with human dignity and all those aspects of life which go to make a man's life meaningful, complete and worth living. It also ruled that the expression personal liberty in Article 21 जो कि है is of the widest amplitude and it covers a variety of rights that go to constitute the personal liberties of a man. The Supreme Court has reaffirmed its judgment in the Menaka case. In the subsequent cases, it has declared the following rights as parts of Article 21, जो कि right to live with human dignity, right to decent environment including pollution free water and air and protection against hazards industry, प्रोटेक्शन एनवायरनमेंट को ठीक ठाक रखना, क्योंकि एनवायरनमेंट अगर पॉल्यूटेड हो गया तो आदमी का रहना मुश्किल होगा. राइट टू लाइवलीहुड, राइट टू प्राइवेसी, राइट टू शेल्टर, राइट टू हेल्थ, राइट टू फ्री एजुकेशन अप टू 14 years of age, right to free legal aid, right against solitary confinement, right to speedy trial, right against handcuffing, right against inhuman treatment, right against delayed acquisition, right to travel abroad, right against bonded labor, right against custodial harassment, right to emergency medical aid, right to timely medical treatment in government hospitals, right not to be driven out of a state, right a fair trial, right of prisoner to have necessities of life, right of women to be treated with decency and dignity, right against public hanging, right to road in hilly areas, right to information, right to reputation, right of appeal from a judgment of conviction, right to family pension, right to social and economic justice and empowerment, right against bar fetters, right to appropriate life insurance policy, right to sleep, right to freedom from noise pollution, right to sustainable development, right to opportunity, right to decent burial cremation. ये सब है. राइट टू मैरी ए पर्सन ऑफ वंस चॉइस, राइट टू डाई with dignity, passive euthanasia, the important cases relating to the expansion of the scope of Article 21st, protection of life and personal liberty are mentioned in. After that, right to education. Article 21A declares that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such a manner as the state may determine. Thus, this provision makes only elementary education a fundamental right and not higher professional education. जो 21A में डिक्लेयर किया गया है, 6 से 14 साल तक स्टेट कंपल्सरी एजुकेशन सभी को देगा. This provision was added by the 86th Constitutional Amendment Act, जो कि 2002 में इंक्लूड किया गया. This amendment is a major milestone in the country's aim to achieve education for all. ये कंट्री का एजुकेशन हासिल करने का ये एक स्ट्रॉन्ग डिसीजंस है. The government described this step as the dawn of the second revolution in the chapter of citizens' right. Even before this amendment, the Constitution contained provisions for free and compulsory education. सभी को free and compulsory education दिया जाएगा for children under Article 45 in Part 4. However, being a directive principle, it was not enforceable by the courts, not there is scope for judicial intervention in this regard. This amendment changed the subject matter of Article 45 in directive principles. It now reads, the state shall endeavor to provide early childhood care and education for all children. सभी को education मिले until they complete the age of 6 years. It also added a new fundamental duty under Article 51 that reads, it shall be the duty of every citizen of India to provide opportunities for education to his child or word between the age of 6 and 14 years. In Annie Krishnanan case itself, the Supreme Court recognized a fundamental rights to primary education in the right to life under Article 21. It held that every child has a right to free education until he completes the age of 14 years. जिसका एज 14 years तक कंप्लीट हो, therefore his her right to education is subject to the limits of economic capacity and development of the state. In this judgment, the court overruled its earlier judgment delivered in Mohini Jain case, wherein it partly declared that there was a fundamental right to education up to any level, including professional education like medicine and engineering. In pursuance of Article 21A, the Parliament enacted the right of children to free and compulsory education, जो कि free and compulsory education 2009. This act sought to provide that every child has a right to be provided full-time elementary education of satisfactory and equitable quality in a formal school which satisfies certain essential norms and standards. This legislation is anchored in the belief that the values of equality, social justice, and democracy and the creation of just and human society can be achieved or achieve किया only through provisions of inclusive elementary education to all. The Constitution, जो कि Constitution 86th Amendment Act 2002 and the Right of Children to Free and Compulsory Education Act 2009 have come into force April 2010. Protection against arrest and detention. Article 22 grants protection to persons who are arrested, जो कि arrested होगा, और detained. Detention is of two types, जो कि two types होता है, namely punitive and preventive. Punitive detention is to punish a person for an offense, किसी को punishment देना, offense committed by him. Her after trial and conviction in a court. Preventive detention, on the other hand, means detention of persons without trial and conviction by the court. Its purpose is not to punish a person for a past offense, but to prevent him, her from committing an offense. उसको बाद वाला जो वो क्या है, वो कुछ इन्वॉल्व है, उसके लिए पनिशमेंट का बदले उसको करेक्शन करना है. Thus, preventive detention is only precautionary measures and based on suspicion. The Article 22 has two parts. उसका दो ठो पार्ट रहता है. The first part deals with the cases of ordinary law and the second part deals with cases of preventive detention law. The first part of Article 22 confers the following rights on a person who is arrested or detained under an ordinary law. Right to be informed of the grounds of arrest. Right to consult and be defended by a legal practitioner. Right to be produced before magistrate within 24 hours, including the journey time. Right to be released after 24 hours unless the magistrate authorize further detention. These safeguards are not available नहीं है to an enemy then or a person arrested or detained under preventive detention law. The Supreme Court also ruled that किसी को भी हम डिटेन नहीं कर पाएंगे अगर उसका कुछ कॉज नहीं है. उसको कोर्ट उसको डिटेन करने के लिए उसको रीजन देना पड़ेगा. The Supreme Court also ruled that the arrest and detention in the first part of Article 22 don't cover arrest under the orders of court, civil arrest, arrest on failure to pay the income tax, and deportation of an alien. Then they apply only to an act of a criminal or quasi criminal nature or some activity prejudicial to public interest. The second part of Article 22 grants protection to persons who are arrested or detained under a preventive detention law. This protection is available to both citizens as well as aliens and includes the following. The detention of a person cannot exceed 3 months unless an advisory board reports sufficient cause for extended detention. The board is to consist of judges of a high court. The grounds of detention should be communicated to the detainee. However, the facts considered to be against the public interest need not be disclosed. The detainee should be afforded an opportunity to make a representation against the detention order. जो आर्टिकल 22 है also authorize the parliament to prescribe the circumstances and the classes of cases in which a person can be detained for more than 3 months under a preventive detention law without obtaining the opinion of an advisory board. Second में है the maximum period for which a person can be detained. एक person detained होना है obtaining the opinion of the detained in any classes of cases under a preventive detention law and the procedure to be followed by an advisory board in an inquiry. The 44th Amendment Act जो कि 1978 में has reduced the period of detention without obtaining the opinion of an advisory board from 3 to 2 months. However, this provision has not yet been brought into force, hence the original period of 3 months still continues. The Constitution has divided the legislative powers with regard to preventive detention between the Parliament and the state legislature. The Parliament has exclusive authority, उसका exclusive authority रहता है to make law of preventive detention for reasons connected with defense, foreign affairs, and the security of India. Both the Parliament as well as the state legislature can concurrently make a law of preventive detention for reasons connected with the security of state, the maintenance of public order, and the maintenance of supplies and service essential to the community. The preventive detention laws made by the parliament वो क्या है ना preventive detention act 1950 जो कि expired in 1969, maintenance of internal security act repealed in 1978, conservation of foreign exchange and prevention of smuggling activities act 1974, national security act 1980, prevention of black marketing and maintenance of supplies of essential commodities act जो कि 1980, terrorist and disruptive activities act टाडा repealed in 1995, prevention of illicit traffic in narcotic drugs and psychotropic substance act 1988, prevention of terrorism act 2002 repealed in 2004, unlawful activities act जो कि 1967 amended किया गया 2004, 2008, 2012 and 2019. It is unfortunate to know that no democratic country in the world has made preventive detention as an integral part of the constitution as has been done in India. It is unknown in USA. It was resorted to the Britain only during First and Second World War time. In India, preventive detention existed even during the British rule. For example, the Bengal State Prisoners Regulation of 1818 and the Defence of India Act of 1939 provided for preventive detention. उसका बाद है राइट अगेंस्ट एक्सप्लॉइटेशन. अगर कोई व्यक्ति एक्सप्लॉइट हो रहा है तो उसको जस्टिस मिलना चाहिए और उसको एक्सप्लॉइट कैसे नहीं हो उसका ऊपर ध्यान देना चाहिए. प्रोहिबिशन ऑफ ट्रैफिक इन ह्यूमन बींग्स एंड फोर्स्ड लेबर. आर्टिकल 23 प्रोहिबिट्स ट्रैफिक इन ह्यूमन बींग्स, बेगर जो कि फोर्स्ड लेबर and other similar forms of forced labor. Any contravention of this provision shall be an offense punishable in accordance with the law. अगर कोई काम कर रहा है उसका वेजेस ठीक नहीं मिल रहा है तो वो पनिशेबल होगा. The right is available to both citizens and non-citizens. It protects the individual not only against the state but also against private persons. The expression traffic in human beings include selling and buying of men जो कि बेचना खरीदना, women and children like goods, immoral traffic in women and children including prostitution, dabadasis and slavery. To punish this act, the Parliament has implemented the Immoral Traffic Act 1956. The term beggar means compulsory work without remuneration. It was peculiar Indian system under which the local zamindar sometimes used to force their tenants to render service without any payment. In addition to beggar, the Article 23 prohibits other similar forms of forced labor like bonded labor. The term forced labor means compelling a person to work against his or her will. The word force includes not only physical or legal force but also force arising from the compulsion of economic circumstances. That is working for less than the minimum wage. मिनिमम वेज से कम देना वो भी पनिशेबल है. इन दिस रिगार्ड द बॉन्डेड लेबर सिस्टम, Abolition Act 1976, the Minimum Wages Act 1948, the Contract Labor Act 1970, and Equal Remuneration Act 1976 were made. Article 23 also provides for an exception to this provision. It permits the state to impose compulsory service for public purposes. As for example, military service or social service, ये दोनों for which it is not bound to pay. However, in imposing such service, the state is not permitted to make any discrimination on grounds only of religion, race, caste, or class. After that, prohibition of employment of children in factories, etc. Article 24 prohibits the employment of children below age of 14 years in any factory, mine or other hazardous activities like construction work or railways, but it doesn't prohibit their employment in any harmless or innocent work. The Child Labor जो कि Prohibition and Regulation Act 1986 is the most important law in this direction. In addition, the Employment of Children Act 1938, the Factories Act 1948, the Mines Act 1952, the Merchant Shipping Act 1958, the Plantation Labor Act 1951, the Motor Transport Worker Act 1951, Apprentice Act 1961, The BD and Cigar Workers Act 1966 and other similar acts prohibits the employment of children below certain age. In 1996, the Supreme Court directed the establishment of child labor rehabilitation welfare fund in which the offending employer should deposit a fine 20,000 फाइन उसको देना पड़ेगा फॉर ईच चाइल्ड एम्प्लॉयड बाय हिम. चाइल्ड लेबर एक पनिशेबल है जिसका एज 14 से कम है, उसको कोई हजार्ड्स वर्क में एंगेज नहीं किया जा सकता. अगर कोई किया तो उसका फाइन है और पनिशमेंट भी है. द कमीशंस फॉर प्रोटेक्शन ऑफ चाइल्ड राइट्स एक्ट 2005 was enacted to provide for the establishment of National Commission and State Commissions for protection of child rights and children courts for providing speedy trial of offense. उसको बहुत जल्दी रिकवरी किया जाएगा, उसको बहुत जल्दी स्टेप लिया जाएगा जो कि चिल्ड्रन लेबर चाइल्ड लेबर से इन्वॉल्व है. In 2006, the government banned the employment of children as domestic servants or workers in business establishments like hotels, dhabas, restaurants, shops, factories, resorts, spas, tea shops and so on. कहीं पर भी होटल हुआ, ढाबा हुआ, रेस्टोरेंट हुआ, यहीं पर जो चाइल्ड को रखा जाता है कि डोमेस्टिक काम के लिए रखा जाता है, वो सब बैन है, वो सब ठीक काम नहीं है. द चाइल्ड लेबर Prohibition and Regulation Amendment Act 2016 amended the Child Labor Prohibition and Regulation Act 1986. इसको renamed किया गया the Principal Act as the Child and Adolescent Labor Prohibition and Regulation Act 1986. टुडे दिस मच. ये चैप्टर बहुत ज़्यादा है, इसलिए कल इसका नेक्स्ट पार्ट कवर किया जाएगा. लाइक, शेयर एंड कमेंट दिस वीडियो. थैंक यू.